Let's be honest, losing someone you love is incredibly tough, and the last thing you want to deal with is a mountain of legal paperwork. But, if you've been named an executor for an estate in Mississippi, that's kind of what's on your plate. The good news? You absolutely do not have to figure this out alone. Think of this as your personal roadmap to getting through the probate process with confidence.
So, if this is you right now, you're in the right place. Being named an executor, wow, that's a huge vote of confidence from your loved one. But it's also a really serious legal responsibility, and you're having to do it while you're grieving. So in this explainer, we're going to break down the Mississippi probate process step by step and give you the tools you need to handle it.
All right, let's kick things off with some fantastic news. You might not even have to go through the full, formal, sometimes long probate process at all. Seriously. We're going to look at a couple of shortcuts that could save you a ton of time and, frankly, a lot of stress. So you'll want to listen closely here, because one of these could be your express lane.
Okay, in the world of Mississippi probate, you need to remember one number. It's the magic number, $75,000. If the total value of the estate you're managing is less than that, and we're not counting certain things like the primary home, you might just be able to skip the whole long, drawn-out probate court process. So here are the two main shortcuts you can take. First up, for personal property, we're talking bank accounts, cars, that kind of stuff. There's something called a small estate affidavit. The best part? You can do this just 30 days after the person passed away, and it happens completely outside of court. Now, if there's real estate involved and there's a will, you have another option called muniment of title. This basically lets the court give a quick stamp of approval on the will to transfer the property without making you go through the whole 9 yards.
But what happens if the estate is worth more than that $75,000 magic number? Well, then you're on what we'll call the main road, the full probate process. Don't worry though, we're going to break down that entire timeline for you, from the very beginning to the very end. You'll know exactly what's coming.
Okay, so here's the typical journey, which usually takes somewhere between 6 and 12 months. First, you've got to open the estate and get what are called letters of administration from the court. Think of this as your official license to act as the executor. As soon as that happens, a 90-day clock starts ticking for any creditors to make a claim against the estate. This is a super important waiting period. While that's going on, your job is to create a detailed inventory of every single thing the estate owns. Once that 90-day window is shut, you'll pay off any valid debts and taxes. And then, finally, you get to the last step, distributing what's left to the heirs and officially closing the books. Now, any journey can have a few bumps in the road, right? And probate is no different. Every estate has its own quirks, but there are two issues that pop up all the time: what to do when there's no will, and how you're supposed to handle selling property.
Ah, the classic plot twist. There's no will. So who gets the house? The car? The family photos? When someone passes away intestate, that's just a legal term for dying without a will, you, the executor, don't get to decide. The state of Mississippi has a very specific set of rules that lays out exactly who gets what. And here's that rule book. It's pretty straightforward. If there's a spouse but no kids, the spouse gets everything. Easy. A spouse and one child, they split it right down the middle, 50-50. But check this out. This is where it gets interesting. If there's a surviving spouse and 2 or more children, everybody gets an equal share. So with a spouse and 2 kids, it's not split in half for the kids. It's split into thirds for everyone. The spouse gets a third, and each child gets a third. You might hear this fancy legal term thrown around, per stirpus. It sounds a little intimidating, but it's actually a pretty simple idea. It just means by the branch. So let's say one of the children who was supposed to inherit has already passed away. Well, their share of the inheritance doesn't just disappear. It automatically flows down their family branch to their own kids, the grandchildren. It keeps the inheritance in that family line.
Okay, let's switch gears to another really common task for an executor: selling property. Sometimes you just have to do it. You might need the cash from a house sale to pay off the estate's debts or to cover court costs. And other times, it's just the most practical solution. I mean, it is way easier to split cash 3 ways than to have 3 siblings try to co-own a single house, right?
Now, this is maybe the most important thing to remember. You cannot just put a for sale sign in the yard and sell the property like it's your own. You absolutely need the court's permission first. The process is pretty clear. You petition the court, you get a professional appraisal to show you're getting a fair price, and you attend a hearing. Only after a judge signs off and gives you an official court order can you legally sell that property.
We have covered a lot of ground. We've gone over the shortcuts, the main timeline, and the biggest hurdles you might face. So now, let's talk about the final destination: getting the estate closed so everyone can move on.
And more importantly, how to do it in a way that avoids as much stress and family drama as possible.
Let me tell you about a real-world example. An executor, we'll call her Sarah, was stuck. The probate for her uncle's estate was dragging on and on. Family members were starting to disagree on things, and the bills were just piling up. So what did she do? She got court approval to sell the big assets, the house, the truck, for cash. It was a simple, clean move. It paid off the debts, gave the heirs clear funds to split, and she was able to close the estate 4 months ahead of schedule. It's a great reminder that sometimes the cleanest path is the fastest one.
All right, let's wrap up with some of the biggest landmines you need to watch out for. First, be prepared for costs. It typically runs about 3 to 7% of the estate's total value for things like attorney and court fees. And here are the pitfalls to avoid at all costs. Do not drag your feet on creating that asset inventory. Do not miss that 90-day deadline for creditors. But the biggest no-no of all is something called self-dealing. This means using estate assets for your own personal gain, like selling the estate's car to yourself for $1. That is the fastest way to get sued and be held personally responsible for the financial damages.
So, as you can see, there are definitely a few twists and turns on this probate journey. But your job as the executor is to honor your loved one's memory by navigating it as smoothly as you can. The key is to really think about the most efficient path for your specific situation, because the ultimate goal here is closure for your family, not conflict.
And that is a wrap on our survival guide to Mississippi probate. We really hope this helps you feel more prepared. Now remember, this is all for educational purposes. Every estate is unique. So for specific legal advice about your situation, please talk to a qualified Mississippi attorney. They really can be your best guide through all of this. Thanks for joining us.